industrial property as well.
Okay, so you're looking at the definitions in the ordinance as use categories as opposed to income producing versus non-income producing. That's the essential difference that you have from our perspective. Is that correct?
That is not correct. I'm looking at the definitions of commercial property, the residential property. If you look at industrial property, that would be income producing. Residential property would be income producing. Adding income producing to doesn't add a lot to the previous definition that we talked about. It's still retail buildings, office buildings, hotels, banks, restaurants. That's the entire business.
But you conveniently failed to look at the current definition of the dictionary. That's the guide to appraisal. You quoted from an obsolete definition. Did you not, Mr. Bell?
First of all, I didn't conveniently, and I took the dictionary off of my shelf. Xeroxed it. I read the definition, which is something you take good. Most people know that anywhere. They don't have this book. This book is not going to be consistent with what the previous edition of the motion was.
All right, there seems to be a problem with the acoustics again in this building, but I think that side of the building has a hole in here for you. Probably go to that. Okay. Who actually gave you that definition, or the definition that you used?
I gave it to myself.
Right. I think you're having a hard time hearing you.
Okay, we're trying to see if we can.
Do you want me to switch sides? I'm a little louder.
Yes, we can from the microphone.
Get the answer that way.
You need to talk, just talk in a voice like a teacher.
Can you hear me?
Yes.
Yes. Please try to speak up loud. So you're saying that you came to testify on this critical issue between commercial and non-commercial, and you personally did not check the current edition of the real estate dictionary, appraisal dictionary.
I don't have the 4th edition. I checked the most recent edition on my shelf of this book.
Are you aware that the 4th edition is from 2002, Mr. Cloud?
I am now. Good.
Now, you have read the ordinance, as I understand, and you know that the commercial provision of it, which you're attempting to avoid, has a fixed definition of the term. Is that correct?
No, it is not correct. I'm not attempting to avoid anything.
Well, you have testified that this is not commercial, okay? You've read the commercial section. Is that correct?
That's correct.
And the commercial section of the ordinance looks at the property here and now as it is. Is that correct?
It has wording something like that. I don't remember the
The
exact word.
improvements that exist at the time of the application. Is that what the ordinance states?
That sounds like part of the commercial definition.
So the improvements that exist on that property at this time consist of an embankment wall. Is that correct?
That is correct.
Is that embankment wall a residential structure?
It is a site improvement.
Is it a residential structure? That's my question. Please answer my question. We'll get through this one.
Okay, I thought I answered your question by telling you what it is. No, it is not a house. It's not a residential. The embankment
It's
is
not
not.
a residential structure.
Answer your question. The embankment is not a residential structure, it's not an apartment building, it is not a house.
And in relying on your conclusion that this is residential, you relied on the zone, you relied on two things, right? Definition of commercial from the older version of the dictionary. And you relied on the fact that Judge Gallipoli gave approvals under the residential for development on 4 of those lots and ruled that the zoning was residential on 2 others. Is that correct?
That is not correct. I did not conclude that the property was residential. I concluded that the property was non-commercial, it was vacant land. I relied on the SR1A, the tax rolls, the judge's decision, and the definitions that I had recited last time.
You didn't refer to the judge's opinion when you testified in saying that it was zoned as residential?
Yes, I just said that 15 seconds ago, that one of the things that I looked at was the judge's decision.
So you relied on the fact that the judge's decision said that the zoning Maryland Mill parcels R2 and R4 respectively. Is that correct?
Yes, that is one of the factors that I considered, but you said I only considered 2 factors.
That and the definition.
And the SR1A form and the tax rolls.
And the SR1A form that shows that it's vacant.
And it shows that it's not commercial property.
It shows that it's vacant, isn't that correct?
Yes, where the box is where you can check commercial property. They didn't check commercial, they checked vacant.
And that again assumes that commercial property is not based on the definition in the real estate appraisal dictionary that indicates that it's become produced. Is that correct?
I can't tell you what the assessor or the division of taxation assumed when they checked off vacant land as opposed to commercial or residential or industrial. It's just a fact that I relied on.
Okay, you relied on the tax record, you relied on an updated definition, and you relied on the judge's ruling that the zoning was R1, R2, and R4. Is that correct?
That's correct.
Okay, now, you heard the testimony of Dean Marchetto at the last meeting, did you not?
Yes, I did.
And Dean Marchetto enumerated the uses that are permitted in the R1 and R2 zones that are other than residential. Did you hear that?
I do remember he was reciting uses for the yes.
Okay, and do you recall that he testified that houses of worship are permitted in the R1 and R2 zones?
Yes, a house of worship would be another classification on the SR1A. That would be a 15, which is an exempt property.
So the R1, I'm not asking you about the tax rules, I'm asking you now from the zoning perspective. Is a house of worship residential?
A house of worship is a religious institution. It's not residential.
Thank you. Is it park or playground residential? You can just say yes or no.
No.
Are essential services in school residential?
No.
Are government uses residential?
Not used.
So there are uses in the R1 and R2 zones that are not residential, is that correct?
That is correct.
Now, with regard to Judge Gallipoli's decisions on the Monmouth, New Jersey period coal lots, in which he essentially awarded as of right approvals for townhouse development at grade. Because the owner has these approvals, would there be anything to preclude the owner from using any, converting the owner to an approval for any other use permitted in the zone?
If I understand your question, no.
So that the owner could go for non-residential use?
The owner could go for a house of worship, a government use, if he was a park or a playground.
So the mere fact that it is zoned R1 or R2 is not dispositive of whether or not it's residential. Isn't that correct?
No, the property is vacant land. The zoning
No,
just
I'm
allows
asking
the
you,
permitted uses.
You said you had 3 reasons. Don't go mixing and matching. Take your tax things and put them over here. Take your definition, which we know is not any good, put that over here. And let's talk about the zoning. Let's just stick with the zoning. And under the zoning, okay, is there anything to prevent the current owner from or owners or any future owner from using these properties for the non-residential uses that are in the R1 and R2 zones?
No, the owner could use,
Calls for a yes or no.
the owner can use the property for any of the non-commercial uses allowed by the zoning ordinance.
Is there anything in Judge Gallipoli's decision, the orders or his decision, that indicates that his determination as to the zoning has anything whatsoever to do with the hardship exemption?
I did not see anything that suggested that.
Now, you're an attorney, so you're an attorney and an appraiser, so you have kind of a combination of skills. But as an attorney, are you aware that land use boards, including historic preservation commissions, are bound to comply with the ordinances that govern them?
I would say yes, both as an appraiser and as an attorney.
Excellent. Now, you stated that you would want to see the contracts, the purchase contracts, to evaluate the land value. Is that correct?
Well, I thought it would be important to see the underlying contract as well as the leases with the billboards to understand the investment and all the rights and obligations that went with it.
Now, are you aware that the ordinance that addresses the non-commercial basis requires you to submit the deeds?
I am aware that the non-conforming, the non-commercial part of the ordinance has a long list of things that might be of interest to the commission. I don't know more specifically. All of those items, deeds and financial information and all sorts of things are listed in that section.
Is there anything in the section that requires the submission of contracts of sale?
My recollection is that anything that is of interest to the commission that they deem relevant, but I don't recall anything that specifically requires a contract of sale.
And as an appraiser, you're trying to determine what the sale price of the property is. What do you look at?
Well, as an appraiser, one of the things that when available we're supposed to look at is contracts as well as closing statements, deeds, other zoning approvals, depending on the circumstances and what it is that you're appraising.
But isn't the deed what is really looked at to determine what the sale price is?
The deed is one thing that is looked at, but if you look at a deed and you don't know whether something has approvals or doesn't have approvals, it's difficult to compare apples to apples. So if you're appraising vacant land and you have a sale of 2 properties, one vacant lot sold for $500,000, the other vacant lot sold for $100,000, you need to know whether one had approvals and one didn't. So you're comparing the right sale to the circumstances of the property.
So this was vacant land. I'm telling you that, and you can see by looking at Judge Gallipoli's opinions, that it was the current owner to obtain the approvals for those properties. Is that correct?
Yes.
So there were no approvals on these properties prior to that time?
I don't know if there were ever approvals prior to that time, but the owner, after they purchased the property, got approvals enhancing the value and utility of the property.
So you acknowledge that land has different values depending upon whether or not that land has approvals?
Yes, land has different values, and not just whether or not it has approvals, but where it is in the approval process. So, for instance, a property that doesn't have approvals, but is the day before they're going to vote on the approvals, and done the environmental and engineering studies, is more valuable than a property where there's not sure if I understand the question.
In communities that follow the law, you admitted previously, and agreed, that both as an attorney and an appraiser, that there is a requirement that localities abide by the ordinances that govern. You've never heard the term as of right approvals?
Yes.
So what's an as of right approval?
You have a 25 by 100 lot, lot size of 500 square feet. You don't need any variances. In that situation, approvals are not worth as much as on the property where it's more difficult. You spend more time and money in that process of creating more value than the ones where it's as of right.
So the as of right estate properties are properties which the municipality is obliged to approve. That's what we had discussed previously. Is that correct?
Generally speaking, that would be correct.
So a law-abiding municipality could be one that would approve as of right application to the ballot. Is that correct?
Generally speaking, but there's always other factors that you can have something as of right and it's a 25 by 100 foot lot and you meet all the criteria, but it's contaminated.
I didn't ask you that.
I'm giving examples. There is a situation where, although it's as of right, they might not give you the approvals of all sorts of other things in the village.
If we're talking about that particular issue at the moment, a planning board could not deny an as of right approval because someone would need to perhaps get some clearances and something that would be done by the New Jersey Department of Environmental Protection. Is that correct?
So what would happen is you would get approvals subject to all sorts of other approvals and permits, and until that happens, you still can't build.
So let's go back then to what I'm talking about, which is the municipality approving a piece of property based on zoning. That's what we're talking about as of right for zoning purposes. Okay? Not with conditions placed on them that would require subsequent governmental approval. So a law-abiding municipality could approve as of right, zoning as of right applications. Is that correct?
Generally, it has an answer, but generally speaking, when you don't need to get any variances and there's no special circumstances, that the approvals as of right usually are given for those special circumstances.
Unless, but I want to go back to this because you're going back to the special circumstances. You have an ordinance. An application meets all the requirements of the ordinance. No variances and no design requirements. Talking zoning now, just so mixing up anything else. Zoning only. You have an application that meets all of the zoning and all of the design standards. Isn't that an as of right application that an ordinance is compelled to grant?
I'm not a zoning attorney, but generally speaking, that if you meet all the requirements, you get your approvals.
And isn't that in fact what the Supreme Court announced in the famous case of Islamia? That's the decision, isn't it?
It might be a famous case, but I don't know.
Now, you criticize the testimony of Mr. Brody and Mr. Howell about their allocation of land value to these properties. Isn't that correct?
That is not correct. What I did was compare the land values that Mr. Powell and Mr. Brody came up with. They were done slightly differently, and they both came out very close to the same answer. Mr. Brody said the lots were worth, I think, $75,000 a lot. Mr. Powell said it was the land was worth $35 a square foot based on the size of the improvement. He was opining that the improvements were going to be 2,100 square feet. I know that was conflicting.
Let's stick with the
Well,
land.
but $35
$35
a square foot times 2,100 square feet is very, very consistent with what Mr. Brody said.
Okay, but did you have a problem with Mr. Brody's testimony?
The only thing that I said that Mr. Brody, and he was very candid, and Mr. Powell both explained what properties were selling for in Jersey City. And they were both very candid and told you that in their study, they were having all properties, both the residential properties, whether it was 100 years old or 60 years old, and they said this is the range that properties sell for. They were both consistent, and they both made sure you understood that that was not a study of new housing. And all I suggested was it has to do. I know Mr. Brody could tell you what new housing or unique housing like this might sell for.
Let me try to go back to the question that I initially asked. Both witnesses allocated a portion of the total value of the property to the value of the land. Isn't that correct?
Well, my recollection is that Mr. Brody testified to what the value of the land was. He didn't testify beyond that, what the total value of the property was. But Mr. Powell was doing it in the context of a feasibility study, and he had some other factors that he included.
Both of them separated out one factor as to the value of the land. Is that correct?
You have to be more specific.
Didn't each of the witnesses testified as to various elements of cost of development of the property. Is that correct?
Both Mr. Powell and Mr. Brody both had an estimate of the cost to develop the housing. I believe Mr. Brody was at, I have some notes, but I think he was $180 a square foot. That might have been Mr. Powell, kind of certain size. And I know we heard testimony.
I'm trying to just take issue by issue, and if we could just stick with issue by issue, I think we can do it. I have tried about my questions to ask about the value of the land, separated from the cost of the building, the extraordinary, starting with the value of the land.
Yes, Mr. Brody was at $75,000 a lot, and Mr. Powell was at $35 a square foot, times 2,100 square feet. That's the value of the land that they testified to.
Did you express some disfavor or criticism of those two land values?
No, I did not.
So you don't think that the land value was wrong? You think they were fine?
I didn't praise the land. What I testified to is that they were consistent and that the land value that Mr. Powell came up with, which was on that chart of 12 million something, is a lot more than the value of the land paid for by the developer.
Okay. That's where I'm trying to, you said that the developer paid for 8 parcels of land, $3 million, and their assessment was higher. So that was your problem with what they said, is that correct?
If you talk about it all night, I've answered that question. I didn't have a problem. You keep asking me about the problem there. I didn't have a problem on their analysis of the land.
They should have done this.
But aren't you assuming that the $3 million purchase price, which we previously discussed was without approvals, aren't you assuming that the prices that Mr. Powell and Brody referred to were lands with approvals?
I wasn't assuming anything. I was stating the facts that what the purchase price was and what the land value was that the gentleman testified to.
And in your comments in that regard, did you consider the fact that Messrs. Brody and Powell, in referring to land value, were referring to land value with approvals? So the purchase price is the raw land. We just went over that, didn't
The
we?
purchase price is the raw land, and getting approvals, as we just talked about, increases the value of land.
So then the fact that the $3 million purchase price doesn't equate to the square foot price or per lot price that we're referring to really is irrelevant because $3 million doesn't reflect the value of the approvals. Isn't that correct?
You are correct. The $3 million is without the approvals, and as they go through the approval process, the land is more valuable. You can sell it for more money.
Now, with regard to the hardship application, this venture of the fiction of putting 2-family houses on top of units, okay? The land value itself is the same regardless of whether the housing is on the top or the bottom. Is it on a grade or on the top? Is that correct?
I don't know. You're going to have to ask Mr. Brody and Mr. Powell.
Well, how would the land value change if you were going to build on top floor or at grade? The land value is the land value, is it not?
Well, the difference is the $75,000 a lot was for much smaller lots, but more lots. That's necessarily the same value as a half-acre lot that's going to have a 5,000 square foot home.
I didn't ask you about that yet.
But I'm explaining why it can be different.
If we search you built it on top of the pool, there were certain costs, extraordinary costs that would be incurred. Is that correct?
Yes, you
And
put
let's
on
stick with that.
testimony to that effect.
Let's just stick with that right there. That's what we're dealing with. Okay? So we identified the differential of the two-family houses at grade versus the two-family houses on the top of the pool. Now, in that circumstance, does the value of the land matter, whether it's at grade or on the top of the pool?
I couldn't tell you I haven't valued the land.
But assuming that you know the value of the land, take Mr. Rhodey's number for an example. Would it change if you built on top of the pool or if you built at grade?
The value of the land could be more valuable on top of the wall, on top of the embankment, if those properties would sell more for being in a unique location.
But you never assessed it.
I haven't appraised the land, but the difference is, if there's a premium, you heard testimony about Mr. Brody and Marquetta talk about the possibility of a premium by being up high. You also talk about extraordinary costs, but if a premium, to get a premium, you might be willing to pay more for it.
You're again going back to the single family option. That was the only time the witnesses ever spoke about the possible premium of building on an elevation. Isn't that correct, Mr. Cloud?
I'm not going to tell you.
Well, the record will reflect that their testimony about potential enhanced value of building on top of the wall was strictly limited to the possible idea of presenting single-family development. With respect to the two-family, you haven't done any studies to look at properties and houses being built, two-family houses being built on top of a structure such as this. Is that right?
Not saying in this case, but I can tell you that any time you have a property that's going to residential property that's going to have better views, which you would have to build up starting much higher, you're going to get higher prices.
So you're referring to have somebody building up on the top of a mountain. Is that correct? That would show that type of sale.
Well, all sorts of views, having a view of the Hudson River versus not the Hudson River, being on the 15th floor of the part of the high-rise versus being on the first floor. You do studies, and the higher you go, you get a better view of Manhattan, the more valuable the property is.
Any of these studies. And have you studied any of these things? Did you present any evidence to support this opinion that you now learned further?
As I just answered, not this case, but appraisers do that all the time.
Are any of those studies applicable to the construction of housing on top of an embankment wall where you have to go into a hazardous structure in order to gain access?
The studies that we're talking about have nothing to do with cost.
Thank you. But they have nothing to do with this type of structure, do they?
We were just talking about elevation and views.
In other circumstances, dissimilar to what we have before us.
I would say other circumstances that are similar in having high views.
Now, did you state that in order to evaluate the hardship, you'd have to evaluate what the owner would get back, basically their profit, their development?
I testified that one of the things to consider is what the whole deal, what was the purchase price and what the property be sold for.
Can you please tell me where in the non-commercial section of the ordinance that type of inquiry is authorized?
I don't recall specifically the non-conforming part of the ordinance is wrong. I was suggesting that analysis as a real estate appraisal.
So you kind of implanted your own spin on what would be the get back, so to speak. It's not in the ordinance.
You have to show me the ordinance, but the ordinance is vague, less specific than the commercial part, and that seems to be a reasonable way to return to see a return to be paid.
But is there anywhere in the ordinance that says that this commission has the authority to ascertain the net profit that someone would make in developing a particular piece of property?
I don't recall the ordinance says what the ordinance says.
Mr. Cloud, you've been here for how many meetings have you been sitting here?
I guess we started at about 5.
And you don't know what the ordinance says?
The non-conforming part of the ordinance, which is
Non-commercial.
non-commercial, thank you, is about a page and a half, and I have not memorized it. You want to read it out loud? You want to read it out loud?
You're a witness. You don't know the ordinance of the testimony, so that's your choice. Refers to billboards, okay? You seem to think that somehow we should, Conrail or this commission should look at the possibility of a renewal or leases for the billboards and to see what kind of income can be generated. Is that correct?
What I suggested to the commission is commissioners had questions about the income. It was testified that the income is de minimis, and all I suggested is if you're interested in what the income is to billboards, the fact that it's de minimis now doesn't mean when the next term or that it could go to market rent tomorrow. And the only way to understand if it's de minimis forever, below market or above market, is to start by looking at the lease itself.
And you understand the lease is confidential.
Sure.
I heard testimony that it was confidential.
Are you aware what the size of the employment billboards? Have you seen them?
I've seen it, but I don't really remember.
So if I told you they were really what I think they're called poster boards, do you remember that they were the size of the billboard that was there on the highway?
I remember the testimony was like a poster boards.
Do you know what the approximate size of the billboards?
I don't.
Do you know whether or not this is a particularly well-trafficked area that would have a lot of traffic for purposes of gaining advertising revenue?
I'm not a billboard expert, but all I was suggesting is that when we look at the lease and see it, that it could have been a 15-year term, and the rent was sent 15 years ago, and it bumps up to another number in the next term.
Are you seriously suggesting that you reach 12% of the assessed value?
I don't know. I'm not saying no idea. We don't even know what the rent is.
But looking at the size of those poster boards, do you seriously think that they could gain any significant income based on their size and their location and their visibility?
I know nothing about the facts of the billboards other than what's testified. It's de minimis. We can't tell you what it is, but we want to retain it.
Now, did you have a concern that our witnesses did not testify as to the future value of what might be constructed? Did you say anything to that effect?
I do not think I did.
So you don't have any criticism that they didn't attempt to project the value?
I'm not sure if I understand.
No, I listened to your testimony, and I tried to understand what was stated, and I thought you said that the witnesses did not project the future value of the housing. That's what you said.
During the testimony, we were told by Mr. Powell and Mr. Brody, in the part of the analysis, the important Mr. Powell's analysis, is here's what housing sells for. That's not similar to the subject in that his study did not include just new housing, and that you couldn't build it for what you could sell housing that might be 60, 100, 5 years old. And I suggested that the right way to do that is to compare that cost to what new housing like this would sell for. And that wasn't done, not that they didn't project something into the future.
Are you aware that the ordinance requires this board to consider anything the current value of the property?
I do recall that, yes.
Is there anything in the ordinance that allows this commission to look at the future value?
I'm talking about your witness's testimony, but in their feasibility analysis on what houses would sell for if they were built.
You criticize the witnesses for not projecting the future value of the housing. Is that correct?
I complimented the witness's candor for pointing out that what they did included all of those old houses and all sorts of things so that the commission would not be confused. But that it wasn't apples to apples.
What does that have to do with the provisions of the ordinance? Can you tell me how that relates to anything in the ordinance?
The comment has to do with the feasibility study, and Mr. Powell said that this project is not feasible the way he presented the evidence. What I suggested is, rather than say apples to apples, it's you got
But my question again, I asked the question was, is there anything in the ordinance that would require you to project the future sale price of the house?
I don't think there was anything I can recall in the ordinance that required Mr. Powell and Mr. Brody to project what housing might sell for, but they were free to put on the case the way they would like to.
Now, you basically opined that we didn't prove the hardship of the non-commercial criteria. Is that correct?
That's correct.
You made no statement as to the commercial because you do not believe you fall in that category. Is that correct?
That's correct.
So your opinion is limited solely to the non-commercial basis.
My opinion was that this is non-commercial, and as non-commercial, I believe my answer to that.
As an appraiser, is it common to classify properties between income producing and non-income producing?
Yes.
Now, perhaps wearing both hats, are you familiar with the term inverse condemnation?
Yes, I am.
Okay, so what does inverse condemnation mean?
Inverse condemnation is something that's very difficult to prove, but it means that the property has absolutely no utility. It's even wetlands. The zoning doesn't create an inverse condemnation. Zoning something open space isn't quite enough, but there are certain circumstances, and it's very rare, where a property can be zoned into utility.
So, this is a constitutional principle, is it not?
Yes, it is.
And government cannot constitutionally deprive someone of utility in their property. In their property.
Government can deny utility of your property all the time. It's zoning. They can take a property that lets you build 10 houses, and they can put in buffers and wetlands, reduce it so you can't build at all. But they can't deny you something even less than preventing you from building a wetland, something even less than that.
So they cannot, as I said, deny the property owner of utility. You have some reasonable return for the property. Is that correct?
I'm not a constitutional scholar, so I don't want to get into the words of utility. I can tell you that wetlands, conservation, that does not get to the level of an inverse condemnation. So it's got to be even less than that. That's not a property that's getting a return for this use.
Right, because there's some issue there. There's so there has to be something that you use. If someone needs a whole utility for the property to really be constitutionally sustainable.
Again, I'm not a constitutional scholar. I can tell you it's one of the hardest things to prove, and government has the right to downzone and do all sorts of things to your property where you can basically not use it, and it's not an inverse condemnation.
You can, excuse me, Mr. Lau, you can have diminution in that. Isn't that correct? Probably can downzone it, there can be diminution.
That's
in that.
correct.
Can they downzone it so that there's no utility in the state of
It's something less than wetlands. Wetlands
Let me
have,
ask you about wetlands, Mr. Lau. I'm asking you
if they make the property so there's no value at all, then perhaps you get to the point of an inverse condemnation.
And that includes the fact that a municipality cannot put a historic designation on a piece of property and therefore make it a public property. Isn't that correct? So what are you not agreeing with?
With your statement, or rather your
So
question.
you think the government can put a historic designation on a piece of property and then make it public property and then that's acceptable?
I'm not commenting on that. The government can put historic designations on property that people use all the time. That's what government can do.
Can they deprive them of all use, all reasonable use?
If they well, again, back to the wetlands example.
I'm not asking you wetlands, I asked you historic preservation.
But you asked me about reasonable use. some value, it's not an inverse condemnation.
Now, if my clients cannot develop this property because this commission will let them demolish the embankment, and they do not give a hardship exemption of any type, what does the client do with this property?
Well, they could build, we heard testimony, they could build two 5,000 square foot homes on each block. There could be other options. They could put up solar panels on the top of the embankment, generate electricity.
And drill for oil.
There's probably other uses that they could do there as well.
So, have you evaluated any of these other uses that are now indicating you can possibly render a return?
I looked into solar power.
Solar power on top of the embankment.
Yes.
And how many private property owners develop solar power on top of the embankment?
By putting solar panels on top of the property, the solar panels can't be taxed as real estate. They can generate revenue or to adjacent buildings, build a building on part of the property that is not on the embankment, and generate electricity.
And a whopping 10 people here this
For
time.
that property, you can also get credits as a secondary market where they're allowed to sell.
So they have to become public utilities.
No, you can't become a public utility. You can't just sell
This time we got a whopping 10 people.
power to the public at large, but you can do it to your own property, build on the adjacent property that you own.
So if someone put solar panels on top of the embankment, where they going to be built?
They're going to put it on the other two blocks that have approval where they can build a property that the developer already owns.
Have you evaluated the economic feasibility of this, or are you just looking at this as pie in the sky?
Yes, I talked to an expert on this. Generally,
Who did you speak to?
Rick Holmes from EVP Solar. Generally, we get about 50 cents a square foot for rooftop or for vacant land. That's called the solar field. These properties would generate less than 50 cents a square foot because of the angle where the sun is, the exposure, and because there's some buildings that would be blocking some of the sun. So this property would get less than 50 cents a square foot. But if you would think of a 40,000 square foot block, 100 by 400, typically that would be about $20,000. The reality is these properties would generate less.
And if they were to put these solar panels, would they then fall into the commercial standards of the ordinance for hardship?
No, very recently the legislature and the governor signed a bill which says these properties, the solar panels are personal property, they can't be taxed. Property must still be assessed as vacant land.
Isn't that a private home?
No, the Meadowlands Convention Center, high schools, the sewerage authority, I think in Hudson County has it on the roofs.
Let's stop talking about some idea about making solar panels all over the top. You recognize that that would be done. That would be the use and that would be the end, right? But you haven't ever costed it out. You have no idea as to its feasibility. Do you? It's something that someone can look into because there's been no testimony or evidence before this board other than your casual conversation with someone. Isn't that correct?
No, until you asked me, there was no testimony, but I had not a casual conversation. I'd like to have 40 pages of documents in my briefcase on this. I interviewed the guy for a long time. Yes, I do. Photographs of rooftop fields, including examples of Hudson County. Would you like me to get them?
No. Now, you also stated that you thought that there would be less expensive ways to develop on top of something embankment. Isn't that correct?
Yes, I thought that maybe that there could be less expensive ways.
Putting aside the development for your repeated references to the single-family option, right? Putting that aside for the moment, what other uses did you consider other than less expensive means of building the zone uses?
I do not consider any other uses. We heard something about a $30 million part of cost that it did for this steel structure. And in my experience, as an appraiser, when you get more than one bid, you'll find that someone will come in with a lower or a different creative plan. I'm not saying that those numbers weren't right. I'm just saying if you got 3 bidders, it wouldn't surprise me if someone was significantly lower.
But you really have no proof to show that there is anything less expensive, is that correct?
That's correct.
You're not an engineer.
That's correct.
You're not an architect.
No.
You understand that you have renowned experts in both fields that evaluate bids to assess how to build a concrete base, is that correct?
I heard the testimony from the architect. I was impressed with his testimony. I heard the testimony from the engineer. The engineer's testimony was very non-specific. I didn't hear where the numbers came from. It was a lump sum number. I didn't hear how much for the pilings or how much for this or how much for that. I was less impressed with the engineer. I was more impressed with the architect.
So he's not reality. This is
That was not.
Didn't you hear Mr. Sarah as he explained the necessity of constructing structural depth, putting low improvements on top of the wall?
Yes, I heard his testimony, yes.
And then didn't Mr. Marchetto essentially confirm and refine that testimony by more details?
I did not hear details on the cost, where the numbers came from, the size of, for instance, if there was a piling, how big a piling, what kind of piling. You use the evaluation service like Marshall and Swift. It gets very specific. You can see the numbers. Normally, when I'm in court, there are numbers to look at where you can see how the math is done, to see where the numbers came from. My comment was there was no way to determine that here. Just $31 million. We say so.
Did Mr. Caceres submit specific documentation last week that showed how much cubic footage the bill had to be removed and how much it would cost for the structural steel? Wasn't that all detailed?
Not that I saw.
Oh, not that you heard, not that you chose to. Using Marshall and Swift, don't you have to have a design first, Mr. Platt?
Well, you can do it with a design, but you don't have to have a design. You can use Marshall and Swift. Let's say I'm going to construct a 50,000 square foot masonry course, including go gauge. You can see what the number is. Adjust it for your region, what part of New Jersey, what size brick. You don't have to have a design beyond knowing what it is that you're trying to determine your construction.
So, are you telling me you can go to Marshall and Swift and find out how to build and cost out a structural depth such as is necessary for construction in this instance, that it has the detail on the structural depth of that nature without having a design first?
Yes, Marshall and Swift has a section where it's placement cost and reproduction cost. And reproduction cost is something where you're going brick by brick as opposed to doing a nursing home, for instance, 50,000 square feet times a certain number. They can actually break it out component by component, how much for the floor, what kind of floor, how thick are the walls, and it can be done that way. It's a much more detailed part of the evaluation guide.
Can you show me the evaluation guide where it would give you guidance as to how to cost out a structural depth such as proposed or necessary in this instance?
Sure, there's a section if you give me the book, there's a
I
section.
don't have it. You're the one who's doing this in line.
I didn't know you were going to ask the question, but there's a section that deals with depths.
Structural depths that are built within and on top of stone walls such as we have in this instance.
Marshall does not take into consideration, it doesn't talk about the land, but it would do it. You need pilings. You decide, let's say I need 50 feet as opposed to no pilings. You can request how much the piling might be based on how deep you're going, but it doesn't have a section on describing the land.
Okay, so you just think that they could shop around and they could find somebody else come up with a lesser price for the
surprise me.
It wouldn't surprise you, but you don't really have anything to say that it is, it's just an item. Now, are you also suggesting that the house itself be constructed in a less expensive manner?
Yes, we heard testimony last week by the architect that cheaper housing, intermediate housing, and luxury housing. I don't think anyone is in disagreement about that.
Okay, and you do understand that these applicants, in submitting the plans that they did and obtaining approval on the model Jersey Beauty coal blocks, shows a high quality product. Is that correct?
I certainly heard testimony all the time. That's what government can do.
Can they deprive them of all use, all reasonable use?
If they love, again, back to the wetlands example.
I'm not asking you weapons, I asked you historic preservation.
But you asked me about reasonable use. They can't deprive you of, make your property have no value. As long as you have some value, it's not an adverse condemnation.
Now, if my clients cannot develop this property because this commission will let them demolish the embankment, and they do not give a hardship exemption of any type, what does the client do with this property?
Well, they could build, we heard testimony, they could build two 5,000 square foot homes on each block. There could be other options. They could put up solar panels on the top of the embankment, generate electricity.
And drill for
There's
oil.
probably other uses that they could do there as well.
So, have you evaluated any of these other uses that were now indicated you could possibly render a return?
I've looked into solar power.
Solar power on top of the embankment.
Yes.
And how many private property will develop solar power on top of the embankment?
By putting solar panels on top of the property, the solar panels can't be taxed as real estate. They can generate revenue or to adjacent building, build a building on part of the property that is not on the embankment. They can generate electricity.
And a whopping 10 people here this
For
time.
that property, you can also get credits as a secondary market where they're allowed to sell.
So they have to become public utilities.
No, you can't become a public utility. You can't just sell
This time we got a whopping 10 people.
power to the public at large, but you can do it to your own property, build on the adjacent property that you own.
So if someone would put solar panels on top of the embankment, where they going to be building?
They're going to put it on the other two blocks that have approval where they can build a property that the developer or they owns.
Have you evaluated the economic feasibility of this, or are you just looking at this as pie in the sky?
Yes, I talked to an expert on this. Generally,
Who did you speak to?
Rick Holmes from EVP Solar. Generally, we get about 50 cents a square foot for rooftop or for vacant land. What's called a solar field. These properties would generate less than 50 cents a square foot because of the angle where the sun is, the exposure, and because there's some buildings that would be blocking some of the sun. So this property would get less than 50 cents a square foot. But if you would think of a 40,000 square foot block, 100 by 400, typically that would be about $20,000. The reality is these properties would generate less.
And if they were to put these solar panels, would they then fall into the commercial standards of the ordinance commercial?
No, very recently the legislature, the governor signed a bill which says these properties, solar panels are personal property, they can't be taxed. Property must still be assessed as vacant land.
Isn't that a private home, Mr. Webb?
No, the Meadowlands Convention Center, high schools, the Sewerage Authority, I think in Hudson County has it on the roofs.
Let's do this, okay? Let's stop talking about some idea about making solar panels all over the top. You recognize that that would be done. That would be the use and that would be the end, right? But you haven't ever costed it out. You have no idea as to its feasibility, do you? It's something that someone could look into. Because there's been no testimony or evidence before this board other than your casual conversation with some
No, until you asked me, there was no testimony, but I had not a casual conversation. I might have 40 pages of documents in my briefcase on this. I interviewed the guy for a long time. Yes, I do. Photographs of rooftop fields, including examples of Swenson County. Would you like me to get them?
No. Now, you also stated that you thought that there would be less expensive ways to develop on top of the embankment. Isn't that correct?
Yes, I thought that maybe that there could be less expensive ways.
And you put aside the development for your repeated references to the single-family homes, correct? Putting that aside at the moment, what other uses did you consider other than the less expensive means of building the zone uses?
I did not consider any other uses. We heard something about a $30 million part of the cost that it was steel structure. And in my experience, as an appraiser, when you get more than one bid, you'll find that someone will come in with a lower or a different creative plan. I'm not saying that those numbers weren't right. I'm just saying if you got 3 bidders, it wouldn't surprise me if someone was significantly lower.
But you really have no proof to show that there is anything less expensive, is that correct?
That's correct.
You're not an engineer.
That's correct.
You're not an architect. You understand that you have renowned experts in all fields that evaluate this to assess how to build those non-conventions, is that correct?
I heard the testimony from the architect. I was impressed with his testimony. I heard the testimony from the engineer. The engineer's testimony was very non-specific. I didn't hear where the numbers came from. It was a lump sum number. I didn't hear how much for the pilings or how much for this or how much for that. I was less impressed with the engineer. I was more impressed with the architect.
So he's not reality. This is
That was not.
Didn't you hear Mr. Sarah as he explained the necessity of constructing structural depth and putting all those improvements on top of the wall?
Yes, I heard his testimony, yes.
And then didn't Mr. Marchetto essentially confirm and refine that testimony by more details?
I did not hear details on the cost, where the numbers came from, the size of, for instance, if there was a piling, how big a piling, what kind of piling. You use a valuation service like Marshall and Swift. It gets very specific. You can see the numbers. Normally, when I'm in court, and there are numbers to look at, and you can see how the math is done to see where the numbers came from. My comment was there was no way to determine that here. Just $31 million. Let me say something.
Did Mr. Sarah submit specific documentation last week that showed how much cubic footage the building had to be removed and how much the cost of the structural steel? Wasn't that all detailed?
Not that I saw.
Oh, not that you heard, not that you chose to. Using Marshall and Swift, don't you have to have a design first, Mr. Platt?
Well, you can do it with a design, but you don't have to have a design. You can use Marshall and Swift. Let's say I'm going to construct a 50,000 square foot masonry nursing home. You go to a page, you can see what the number is, adjust it for your region, what part of New Jersey, what size brick. You don't have to have a design beyond knowing what it is that you're trying to determine your construction.
So, are you telling me you can go to Marshall and Swift and find out how to build and cost out a structural depth such as would be necessary for construction in this instance, that it has the detail on the structural depth of that nature without having a design first?
Yes, Marshall and Swift has a section where it's replacement cost and reproduction cost. And reproduction cost is something where you're going brick by brick as opposed to doing a nursing home, for instance, 50,000 square feet times a certain number. They can actually break it out component by component, how much for the floor, what kind of floor, how thick are the walls, and it can be done that way. It's a much more detailed part.
Can you show me the evaluation guide where it would give you guidance as to how to cost out a structural deck such as proposed or necessary in this instance?
Sure, there's a section, if you give me the book, there's a
I
section.
don't have it. You're the one who's the witness in the line.
I didn't know you were going to ask the question, but there's a section that deals with decks.
Structural decks that are built within and on top of stone walls such as we have in this instance.
Marshall does not take into consideration, it doesn't talk about the land. What it would do is you need pilings. You decide to say I need 50 feet as opposed to no pilings. You can request how much the piling might be based on how deep you're going, but it doesn't have a section on describing the land.
Okay, so you just think that they could shop around and they could find somebody else who come up with a lesser price for the structural work that is necessary in order to build it. That's basically it.
I'm not surprised by this, right?
It wouldn't surprise me. We don't really have anything to say that it is, but it's just an idea. Now, are you also suggesting that the housing itself be constructed in a less expensive manner?
Yes, we heard testimony last week by the architect that cheaper housing, intermediate housing, and luxury housing. I don't think anyone is in disagreement about that.
Okay, and you do understand that these applicants, in submitting the plans that they did and obtaining approval on the model Jersey Area coal blocks, shows a high quality product. Is that correct?
I certainly heard testimony.
Trailers, is that correct? Because we manufacture homes up here, is that correct? That would be less expensive.
I heard his testimony, less expensive, medium expensive, very expensive. I have no disagreement with his testimony.
And if we put up less expensive housing, the comparison, the differential would remain the same, whatever it was, for the extraordinary cost, wouldn't it?
Well, if we're not talking about the extraordinary cost, we're talking about that less expensive, and that wouldn't change, obviously.
And if you had less expensive housing, then the sale price would go up.
That's correct.
So then the profit would you get as much money for a less expensive house as you would for a more expensive house?
But if you're working on the house and you sell it for less, the profit could be the same, more or less.
How are you going to compensate for the extraordinary costs of whatever they are in lowering the purchase price?
Well, kind of we're back to extraordinary costs. My comments were whether lower those costs. We heard the number. The question is whether the $31 million structural steel was necessary or was there other alternatives. We heard some suggestions from the public on that. I'm not an engineer, but I testify to it. It wouldn't surprise me if someone could build the project cheaper, and my reference was to the extraordinary costs.
Okay, so you were not then suggesting that we should come up with less expensive housing, just like pre-manufactured homes or trailers. You weren't talking about that. You're saying you're talking only about the extraordinary costs that we have assessed professional engineers and an architect.
Understand?
Now, perhaps I misunderstood something, but when Mr. Deneen was questioning you about approved projects, did you say that the ordinance doesn't require that owners are entitled to build a approved project?
I don't understand that question.
Mr. Deneen asked you several questions. One of the questions that I understood he asked was whether the owners are entitled to build an approved project, i.e. project in Mount Jersey here in home. Did you render an opinion as to that? Well, if we have an approved project for zoning as of right, do you think the owner is entitled to build an approved project?
If you meet all of the requirements and you have approvals and there's nothing outstanding permits or other issues, then people get to build. And if there's an approved project, but there's other issues, so you don't really have completely approvals,
floating the idea of putting single-family homes on top of the wall, correct?
Yes.
Have you done anything to assess the viability, financial feasibility of such a proposal?
No.
Thank you. Are you aware of the condition of the embankment walls?
I've heard testimony that it varies in different locations in the different lots.
Have you looked at the embankment wall on the Marriott lot, which is the most far eastern most lot?
I don't recall the wall when I looked at it where I was, so I can't describe it.
So you don't know if you can, in coming here and testifying to the board, you don't really know what the condition of the wall is on the Marriott lot?
I would have to look at my notes. I couldn't tell you.
Would you like to look at your notes? Did you find what you were looking for?
Condition of the walls, the Marriott walls, were in bad condition.
In fact, some of the wall, just concrete on the side.
I don't recall.
Okay, now, you're aware that each of these blocks are owned by separate limited liability companies?
Yes.
Now, with respect to your idea that there would be some kind of a solar facility located on top of the walls, did you consider the fact that these are owned by separate entities?
I didn't consider that fact when I was doing the research into solar energy, what it could generate.
And so you don't really know whether or not this idea of transferring the energy from the top wall to another property could be achieved in light of these separate ownership parcels, do you?
I don't think the ownership, I don't know if the ownership, I don't know if the ownership being in separate LLCs with the same would prevent all of them from being used or not. Clearly, it's possible some of them might not be able to be used, but at least ones that are, I would think would be most likely to be would. Can't tell you that first.
Well, so your conclusion was that these applicants did not prove hardship because there could be a less expensive way to develop on top of the walls. Is that correct?
That was one of the plus sales. Right?
Thank you very much for your patience. I have no further questions.
It's time to take a break. Do you intend to recess this?
It's over, we come back, it's open, well, to the commission.
Yes. Oh, well, we're taking 10 minutes, really 10 minutes, back to 10 minutes. It's now 8:10 and 8:40, back to 20. Mr. Donovan?
I'm ready to proceed. I'd like to call Adam Reddick, please.
Would you raise, do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Could you please state and spell your full name for the record?
Adam Reddick, R-E-M-I-C-K.
Thank you. What is your profession?
I'm a professional engineer in the field of civil engineering.
And who are you employed?
CMS.
At the same firm as Lieutenant Sarah would testify?
Yes.
And how long have you been a professional engineer?
Been licensed as a professional engineer for approximately 5 years.
And you testified and qualified to testify before the state?
I've qualified before numerous boards in the state, including the planning board of the city of Jersey City.
If any other questions you want me to take on?
I qualified. Thank you.
Mr. Remick, have you worked closely with Mr. Sarah developing the cause of extraordinary and conventional in connection with the development on top of the embankment?
Yes, I worked very closely with Mr. Sarah.
And there was one piece of information that was not included in the previous submission as requested by the commission, the conventional site improvement cost. Is that correct?
That is correct. Mr. Marchetto provided defined numbers and detailed cost estimates on the extraordinary costs at our previous meeting, and I'm here to present subsequent testimony to support the conventional or common site improvement costs that Mr. Sarah outlined at last week's hearing.
Okay, and is this document the conventional site improvement cost that you have developed?
Yes, please.
And I line by line was associated with the common cost of conventional site improvement?
That is correct.
And this is consistent with the 14 million?
$14.5 million costs that we had discussed over a number of periods.
I have no further questions. I would just like to have this warrant, please. And not have that. So this will be.
Mr. Remick, this is a document, it's
That is correct, yes.
and you have assistance with this as a one-page document,
Yes, I did.
and actually, although it's one page, it has one page, it's on one side, correct?
I'm sorry.
It actually has page one and page two.
It does. That is correct.
And so we're going to mark this. Page 29, one page, lemon cost, 515,
We realize that we're reading both ways of penalties and conventional was not been given. But we neglected to bring the magnifying glass, which is very small.
No way.
But we have to be honest. I can't even see the glass. I have no further questions, Mr. Reddick. I don't know if the commission want to look at those and ask them costs later. These are the costs that are common. Does it increase the cost? Is that correct, Mr. Reddick? These costs are common to develop, they're at grade or on top of the embankment.
That's correct. These are what Mr. Sarah described as
incorporated the extraordinary clause in his presentation, Mr. Nichols. He really did detail them, broke them down.
Yes, well, first of all, I think I had asked to get a copy of that. We haven't received anything. A copy of it.
Not cost, power.
Right, and those clauses are embodied in the powers of administration.
Mr. Marchetta,
The last 3 pages of the powers of administration, that would be the color cover, yes.
I mean, for the record, I certainly don't take any issue at all with E. Marchetto's, improvement costs of structures, per square foot cost or house, but still, the numbers that we've received so far, at least on my recollection, and so far, these are the exceptional costs have been pretty much non-specific. And I'm just saying that this is fine, but this is a differential here of 0, so with respect to this testimony, I have no question.
They were presented, they are in the powers of administration.
The weight of what's in here is in page 28. So I'll take that and put that up. Okay, who's next?
Any questions, Jody? Yes, any questions? If the commission wants to see the PowerPoint demonstration that Mr. Marchetto presented, it breaks down the costs, but I don't know. Okay, I'd like to call Mr. John Burley. Can you name the form from this previous testimony? Okay, Mr. Brody, the first thing I'd like to ask you is, in your previous testimony, you referred to the definitions of commercial that are in various general dictionaries referring to commercial as income.
Yes, that's correct.
And I'm going to show you a document entitled Definitions of Commercial.
Okay.
And this document contains dictionary definitions in the Oxford Dictionary, dictionary.com. Is that correct?
Yes, it does.
And these definitions show that commercial is referring to income producing, does it not?
Yes, it does.
I'd like to ask that this be marked as evidence on 830. And I have several copies here.
Mark 830, this 2-page document is of definitions on the representation. And this is showing that this is in fact exact. You guys spoke to this in the representation that these are actually
Make sure they're in it.
the exact definitions taken out of the book. And it's a 2-page document that we want to press this. You get it. You got 3 of them. You yourself specifically took that. Yes, sir. No, sir.
I specifically did, and I sent them to him. I blocked and copied. The one that is specifically from his book is the 4th edition of the Dictionary of Real Estate Literature. The second, Mr. Timmons,
Wait a
look.
second.
Yes.
So you represent. He can't represent. I
Yes,
asked
I
him
will.
because you asked him that. He seemed to say you did.
I speak
So all I want is
there is one definition there that comes from your dictionary, or the dictionary, is not the dictionary of real estate agreements, that you actually looked at and you know what's actually there.
That's correct.
Independent. Did you have an opportunity to review the transcript and testimony that Mr. Lau made on Monday evening?
Yes, I did.
And in response to that testimony, have you compiled any information regarding the sales of two-family houses that may include some more current homes, or current built homes?
Yes, what I did is to review sales in Jersey City of relatively new two-family homes that sold throughout the city between the time period of 2007 through 2008 through 2009. The most recent sale being March 19, 2009, because there was some criticism relative to the types of sales that we had originally looked at, and that population of sales data included a vast array of some older and some newer two-family and multi-family type homes. Therefore, we went back and looked at what was actually happening as of a very recent time period, and likewise homes that were constructed between the time period of the oldest being 2005 and the most recent being 2008. So they're new two-family homes. And the ranges, the lowest sale price that we found was $360,000. This was a house at 149 Seaview Avenue that sold on November 13, 2008 for $360,000. And the highest sale price that we found was a home at 249 Webster Avenue that sold on November 3rd, 2008 for $650,000. And that was a home that was built in 2008. So the ranges of the numbers between the highs and the lows, and the low really goes between the 400s, the 550s, and so on, indicating, it basically corroborated what our original study was, which I think the record will show is that between 500 and 650,000 plus or minus dollars. And so the low comes down a little bit lower, the high stays pretty much the same as it was. And these are all two-family houses. They're brick, and they're very typical houses. They're not built on an embankment. They're all at street level. They're all on streets within Jersey City with municipal utilities. I looked at them, and they're all pretty average types of homes. Some are a little bit more on the ladder, but they're all pretty much similar type of, quite well, type of dwellings. One of the questions that you had posed to me was, do I believe that, and I don't remember who asked the question, or maybe it been one of the people from the audience, whether I thought that a home on top of the embankment might sell for something more. And it's my opinion that the home on top of the embankment would probably be a higher quality home than the homes that I saw in this particular study, only because of the prominent location in which they would be located in. Whether they would sell for more is a challenging question, particularly in this marketplace. They probably would sell for something more. There probably would be a premium for those houses. How much of a premium? I don't know, because tomorrow all of my 2008 sale numbers could go down the first floor and the upper floor, and that you pay more rent as you go up higher, and likewise as a condominium is sold at a higher floor level, the sale price historically is higher. But these houses they're not going up 32 and 40 stories in height. You're still restricted by the height of the embankment, and likewise by zoning, 30-some odd feet, that you might be able to go above the embankment level based upon variances. So it's not the kind of a high-rise premium that you're going to see overlooking New York skyline or something like that. But it might be a 5 to 15% premium for houses that are built on top of the embankment versus standard homes. There's obviously the extraordinary costs that are attributed to building on top of the embankment. And I've heard and read the testimony of Ted Casera and of others relative to the extraordinary costs. I don't believe, it's kind of a difficult analysis to make because there's still, in my mind, not a totally definitive number that it's, because we haven't done it. And until you do it, you don't know the exact number from the standpoint of contingencies. But there might be an offsetting to some degree between the premium extraordinary costs relative to the premium that you might get, but I don't think you're ever going to get it. I don't think that the extraordinary costs would necessarily be picked up by the prospective purchaser. There would always be a that's not going to be met.
So, in listening to the testimony, you read the testimony, correct?
Yes, I did.
You listened to his answers this evening that he gave.
Yes, I did.
And is there anything that Mr. Blau stated that would cause you to change your view regarding the economic hardships that you encountered in construction going to take place on top of the embankment walls in the two-family construction?
Yes, and I say yes with a caveat. The caveat is that as a professional real estate appraiser, I, along with Mr. Blau, have to abide by what's known as the Uniform Standards of Professional Practice. I taught that course throughout the country for some 20 years. And the most significant aspect of the Uniform Standards of Professional Practice is addressing the concept of communicating something in a manner misleading. And I stand here tonight knowing that behind me is Ted Casara, an architect, an entire team of individuals that has assisted me in arriving at the probable costs to develop the housing on the embankment, and likewise the probable cost to develop those houses on the structural means and the interior that's necessary to have a foundation for those houses. So I can communicate to you in a manner that's not misleading, because this information from my standpoint and knowing the individuals and seeing the spreadsheets is credible. And that's an important word in the definition in the Uniform Standards of Professional Practice. Is it credible? I use martialization every day. I've been familiar with it for 45 years, as long as I've been practicing. I've built shopping centers. I've built condominiums. I know what it takes to build buildings. I'm not an architect. I'm not an engineer. There is no way possible for me as a lay appraiser, or as an appraiser of many, many years, to go into martial evaluation, no matter how well you know, and try to guesstimate what it's going to take to build a a structure inside or on top of that embankment. There are so many intricacies, so many unknowns, that martial valuation just can't start to scratch the surface relative to those kinds of numbers that you need the Ted Casares, that you need the architects to assist you in order to arrive at a credible number. And so when I heard Mr. Blau testify that he could build and he could make it profitable, and I'm not quoting him, it's paraphrasing basically what he said, I don't find that to be credible testimony.
Excuse me, don't characterize that. You can agree or disagree.
Okay, sir.
Please do not characterize.
Okay.
That's the point.
I understand.
If I may, Mr. Janine, do not criticize Mr. Blau for doing the same.
You can say whatever you want.
The record will
Don't
reflect.
characterize that.
Okay. I don't agree with the conclusions that Mr. Blau arrived at based upon the, quote, empirical data that he was considering. There really wasn't any. I mean, yes, it's a Marshall valuation, but again, it's just my interpretation of Marshall and understanding it very well and taking seminars that they gave years ago. But they do give seminars throughout the country in order to understand the utilization of the manuals. And we use the online computer portion of the Marshall valuation today, along with the book we've subscribed to for 40 years. So that's a concern of mine because it's such a paramount question, particularly when you're addressing the non-commercial aspects of this petition, of this application. And the conclusion, again, I don't agree with.
So in your opinion, Mr. Blau's testimony does not meet uniform standards of professional practice for appraisals.
That's correct.
I have no further questions.
I'm a licensed real estate I'm a licensed real estate agent and I specialize in the downtown area only, but I know all of Jersey City. I don't think you can compare Seaview Avenue and Webster Avenue to the value of homes in the downtown area. Are you aware recently of a sale on Wayne Street for $1.1 million?
I'm
This
not.
past November.
I don't know whether.
I was just working with appraisers today, that's all. It was a recent sale, November 24th.
Yeah, I don't know if it was a historical house, a brownstone.
It is, but it's still just you can throw a rock to the
Yeah.
bank. I mean, it is that.
It's possible that, I don't know if it's recorded yet,
Okay.
I don't know when the sale took place.
Because really, Seaview and Webster are nothing like the downtown.
Well, I looked at every one of these and I tried to get sales in the downtown area, but
Well, when we're working with appraisers, we can only use downtown as.
why not? But they're hard. I mean, I didn't try to avoid it. I told my staff, just get me, any Jersey City. I don't care,
Well, downtown is very unique.
I know, but and people aren't moving, and they're not, and don't forget, these are, and I try to get new houses, not necessarily older brownstones, because the subjects wouldn't be older brownstones, they'd be newer houses. Frame, the way they build houses today.
Do you know if that was a restored brownstone?
It was restored,
Yes.
but still, 1.1 in this market was very, very good.
Well, but Mr. Brody,
The uniqueness of the property on the embankment, you can't put a price on the uniqueness of the embankment properties.
Unfortunately, we
Like
don't have a market. We don't have a market.
I specialize in the downtown area, and there are properties like the Climate Mansion, Chocolate Factory, the Opera, the Wells Fargo buildings. These are very, very few properties.
Oh, I agree with you. But we still have to compare, we still have to compare apples to apples.
It's still downtown.
I understand that, and it's the premium for location, location, location.
Exactly, location.
So I agree 100%, but I still, there weren't those sales of houses built in the last 2 or 3 years in that neighborhood. And to try to compare it to something else is not necessarily, in my opinion, apples to apples.
So, Mr. Brewer, are you saying that if you were asked to evaluate what might be the value of a new home on top of the embankment, that you wouldn't use a restored brownstone as a common sale?
I probably would not.
So if I may ask a question, I mean, although there may be a paucity of data, I think Mr. Blau's I think Mr. Blau's point was that if you're going to compare apples to apples, you can't look at a property in a different neighborhood which really doesn't have a relation to a character that's present in the downtown neighborhood. So if you wouldn't compare it to, say, a refurbished or a renovated property, by that same token, I can't really see that you compare it to, say, a property on one of the streets you just mentioned. So isn't that argument folded in the same manner?
Not really, only because there's a buying market out there that's willing to pay X number of dollars for a two-family house in Jersey City. And I agree that there is a premium to living closer to mass communication, light rail, and so on. And some of the sales we picked up were close to light rail facilities. And when you factor in the marketplace today and the buying power and also borrowing power of individuals today, I think that that particular sale, one sale, as you've said many times to your clients, one sale doesn't make the market. I'm sorry, and so everyone may be jumping on that sale and trying to build mortgages on it, and hopefully, it doesn't become a bankruptcy situation somewhere down the line. But again, when we looked at 15, 20 two-family houses, and they reached this kind of a range, and even with a 10 or 15% premium, for location, it's still 350 to 650 number with probably a mean of $525,000. And then you look at the types of numbers that the architects and engineers were reflecting to create housing. And again, without contingencies, there's no cushion in there to create any type of a incentive, in my opinion.
Can I ask, I forgot, I probably heard this, but where are you located? Where is your office located?
My office is in Livingston.
The reason I ask is, I also have personal experience with appraisers and getting, refinancing my property. I live in downtown, and the appraiser that I had used was in Newark, and based upon his appraisal, I never would have gotten a refinance. I had to get something down here, and I got an appraisal double the one that was in Newark. So I submit to you that it's very important to know this specific area. I still have an issue with making comparisons in terms of, appraisal using these properties that you've mentioned, at least the two properties that you mentioned.
Well, one of my better friends of 40 years is Hugh McGuire, who's a well-known appraiser in Jersey City. Right now, I'm probably working on 5 major condemnation cases in Jersey City, Weehawken, Union City, and Hoboken. And they're all condemnations of multifamily type properties, land primarily, and some improvements. And so, I've worked in Hudson County for 40 plus years. I used to represent Margaret Jeffers, who was your assessor here many years ago. But I did all the tax appeals for Jersey City, along with the gentleman I was working for, Mr. Lassiter, for many, many years. And Mr. Curley, who's Jack Curley on commendations in Union City, dealing with multifamily properties. I have an extensive knowledge and background of Hudson County, and I will come up with the same sales that, Hugh McGuire, whose office has been here for 40 years, will both have the same sales in any type of study. Or Stack, who also is a Hoboken Hudson County appraiser, who also trade information with all the time. And so because I'm on the other side of, the river per se, doesn't preclude my ability and knowledge to appraise in Jersey City. And likewise, there are Jersey City appraisers who are appraising in Atlantic City and doing a very incredible job because they study the local market. That's what we're trained to do.
I understand that. I just don't find that disturbing.
Yeah, so you may have had, quote, one bad experience. I don't think that's reflective of the industry.
Mr. Bodie, did you happen to use Liberty Harbor North or any of the townhouses in Liberty Harbor North? Did you use Liberty Harbor North or hear of any of the sales of brownstone buildings, brand new brownstones with elevators in them at Liberty Harbor North?
Yeah, I don't remember who did. I don't think any of these sales were in Liberty Harbor North. But
Because I don't believe any of the townhouses were sold for under $1 million. I don't believe any of them sold for under.
I think you're too close.
I don't believe any of the brownstones sold for under $1 million.
under, as of present time, or are you going back 6 to 9 months or a year?
They're brand new. They've just been selling for the last couple of years.
Are they waterfront, Mr. Sankin?
No,
Are they closer to the water? Well, Liberty Harbor was by closer to the water.
they are on the border of the Van West Park Historic District, right on Grand Street. There are many of them. And that's the thing, they sold immediately.
All I can tell you is I researched for 2008, 2009 sales. That was my task. The more recent sales are where I asked my staff to concentrate, only because you can't use old sales. There's too much of a change in the marketplace. And I didn't cherry pick it. This is the date.
So you didn't do this yourself, this is your staff?
Oh, sure, yes. But I tell them what to do, and they, this one woman who did this and did it for 24 years. It's not-
Oh, I understand, I just asking a question.
Yes.
Does the commission have any questions?
I have no further questions.
Any more witnesses we want to bring forward?
We have no further questions.
At this point, we'll open to the public for comments from the public.
And would you raise your right hand?
I will. I believe I'm sworn in, if you'd like me to.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your full name and provide your address for the record.
Richard James, 31 Bertha Street, Jersey City. Have I got the range? No. Forward again? I've got the range. Mr. Chairman, if I might ask an indulgence of the commission, there are several people in the Preservation Commission who want a short statement.
I'm sorry, yes,
Someone
your voice is low now, I can't hear you. Speak at one even tone, keep dropping off.
There are several members of the Embankment Preservation Coalition who would like to make short statements. It's probably more coherent if we make them one after the other. Is it all right if we go in sequence? Please, the board?
That's fine.
Thank you.
Let's stay on point.
Very short, hopefully, just 10 minutes.
As a short, please stay on point, okay? We're going to get this done and get through this. We don't want to go off on a tangent.
First, let me thank you,
hard work on these important applications. My name is Richard James. I'm a trustee of the Embankment Preservation Coalition. We listened to these applications carefully, but by now, the key points we prepared in response to the applicant's presentations in each session have been better said by your expert witness, so we will spare you the repetition. Because we agree with Mr. Blackwell's expert testimony, we will simply support his testimony with a few additional points. We add a few criticisms of the application, which we find either flawed and believe should be denied. To save your time, we expand on some points in footnotes in our written document, which we are giving to you tonight. 1. The applicant's initial testimony that the embankment is unbuildable was contradicted by the applicant's later presentations and should be discounted. The applicant initially advanced 3 main reasons why a residential development cannot be built atop the embankment, quote, as is where it is. The zoning code, the property's historic designation itself, and the physical characteristics of the embankment. Subsequent to additional material submission and testimony, the applicant acknowledged that a residential development can be built about the top of the embankment, as is where it is, conforming to the existing zoning and sensitive, at least according to the applicant's perspective, to historic status. The applicant even presented a development concept that would obtain, quote, 98% of the areas for which the applicant was willing to accept, quote, entrepreneur risk, unquote. Neither zoning, historic designation, nor the physical characteristics of the embankment prohibit appropriate development. Secondly, we agree with Mr. Black that the Commission should consider the application under the non-commercial category. In addition to Mr. Blau's reasons for considering the site non-commercial, its assessment and transfer of real estate form, vacant land, Judge Coleman's conclusion, definition in the dictionary of real estate appraisers, we refer the Commission to the state's municipal land use ordinance, MLUL, from which our land development ordinance derives its power, for its use of the terms residential and commercial. We note that the term residential describes any instance of housing or dwelling units existing or proposed, while the term commercial denotes property involved in sale of goods or services, also defined as trade. Our written testimony gives many examples, and these are contained in footnotes which I will be giving the board. Under the MLUL, residential is clearly a land use category describing any property development of dwelling units, whether large or small, whether for the use of an individual family or the investment of a large-scale property developer. To go off script for a few seconds, I believe that if we accept the alternative definition as commercial as anything, perhaps it's my fault of hearing, but I believe I heard the alternative definition of commercial as simply anything that would be making money for an owner, get a 2, 3, or 4 family house. Now, I have a fairly good knowledge of downtown Jersey City. I lived there for almost 30 years. I believe that the great majority of the historic neighborhoods that we call basically historic residential neighborhoods are indeed 2, 3, and 4 family. It's a rare single family brownstone. Now, this point is more probably knows this also, but it's a very, very unusual definition of commercial, because any 2, 3, 4 family building would be considered commercial. In conclusion, we further note that the applicant has proposed residential development, presented you with residential development scenarios, and provided figures only for residential development. The applicant has not come before the Commission or any other land board, or even presented any concept proposal in public forums, best of my knowledge, for commercial use of the property. Finally, the applicant claims that when the railroad stopped, the underlying R1, R2, R4 zoning control. The residential zoning is non-commercial. The commission must decide the hardship based on a non-commercial basis. And I'm going to pass to
Mr. Chairman, Mr. Dean, I just have a point of clarification. Was there any intention of making, there's no questioning of the other witnesses, more than that, it's just one comment. Question. And then they have to say it's a fact.
But if there are no questions, we'll close that.
Raise your right hand, please, sworn. Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? And please state and spell your full name for the record and your address.
Dinah Boulevard, DINAHBOLIVAR, 316 6th Street. Our third point is we agree with Mr. Blau that the applicant does not supply enough information for the commission to ascertain whether a hardship exemption is justified. The co-applicant, Conrail, indicated that he has a side agreement with Barstow, yet did not supply this or any other documentation. The underlying contract would also be useful for a hardship analysis. The bid package sent out to bidders indicated the blocks or lots under consideration, plus 2 additional parcels, were all to be sold as one property, and it might be useful to understand why the sale was structured differently. Oral agreements, if any, between the co-applicants and between the co-applicants and other parties should also be made known to the commission. The expert, Mr. Blau, was just questioned as if it was his responsibility to provide information to the commission. It's really the applicant's job to explore ways to improve hardship. Thank you.
Would you raise your right hand, please, sworn? Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? And if you can state and spell your full name and provide your address.
Sure. Christina Donnelly, CHRISTINA Donnelly, DONNELY, 250 5th Street, Jersey City. Point number 4. We believe that the applicant's specific situation cannot reasonably be viewed as a hardship. A common sense view of hardship in the context of historic preservation is extraordinarily burdensome circumstances caused by an act of God, governmental inaction subsequent to purchase, or events beyond one's control. The applicant's circumstances were entirely within his control. The applicant was not only cautioned in a pre-sales document, please note footnote number 2 in our document, that listing on the State Register of Historic Places might affect property use. But Conrail also testified in this hearing that all bidders were notified of the municipal landmark designation during the bid process. The applicant took an investment risk, presumably speculating that the landmark designation could be overturned. If such a risk did not work out as the applicant hoped, it cannot reasonably be viewed as a hardship. Thank you.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? And please state and spell your full name and provide your address.
Jennifer Meyer, MPYUR, 495 Washington Street.
Thank you.
Point number 5. The applicant denies the feasibility of uses proposed by the city and supported by the city master plan and other city and county documents, including light rail and trail. Government-funded studies have examined the embankment's transportation value of the road, express bus, trail, and light. Yet the applicant presents no evidence that these transportation use options, some more historic and beneficial uses than others, have been explored. The applicant simply denies the feasibility of continued historic use as a transportation corridor, saying there is no possibility of replacing site bridges. Point 6. The applicant has not explored other private uses for uses compatible with embankment preservation. Applicant states that, quote, private interests cannot develop for transportation. The Embankment Preservation Coalition does not agree that private interests cannot develop for transportation uses within transportation corridors.
CNJ is an example of one such company which has put an OFA and offer financial assistance before they go out with Conrail to, possibly run this embankment as a railroad. Moreover, transportation in New Jersey is New Jersey's fourth largest industry, and tourism, which goes hand in hand. Transportation is our second largest industry. There are potential transportation-related uses to which the embankment as an historic structure could be put, which will also preserve and maintain its structure and integrity, and which would be economically remunerative. The applicant shows no attempt to explore other uses for the embankment that would potentially enable private property without any use.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? And please state and spell your full name and provide your address.
Bethany Wall, BETHANYWALL, 247 3rd Street. Okay. Our seventh point is that the applicant provides no evidence that the property has been offered for sale at a reasonable price that would avoid hardship. And our eighth point is that, contrary to an early argument in this hearing, the applicant is not entitled to a return on an appraisal based on highest and best use. There's no constitutional guarantee that property owners must enjoy the highest and best use of their property. If that were the case, the city could experience wide-scale destruction and rebuilding to max out property potential. That the Constitution does not serve as an insurance policy that protects property owners against speculative or unreasonable investments. Thanks.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And please state and spell your full name and provide your address.
Peter Delman, DELMAN, 263 5th Street. Conclusion. The applicant needs no, quote, relief valve, unquote, as the applicant refers to the hardship exception. There is no danger of private property being taken for public use without just compensation. The applicant has the burden of persuading the Commission that a hardship exemption is needed. Yet the applicant provides no evidence to the Commission that development proposals that would preserve the embankment while providing a reasonable return were seriously examined with the planning staff or before the land use boards. By the applicant's own admission, there is at least one development scenario that would preserve 98% of the structure while returning a profit. We believe there are many others. Please deny this application for hardship exceptions. Thank you.
Thank you.
Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? And please state and spell your full name and provide your address.
Thank you. We'd just like to thank you for your long service. And we'd like to put a note in the record that we respectfully object to the consent order to which Jersey City agreed to ignore abandonment status, title, and ownership because we feel that these items are relevant to economic hardship. And we also object to the applicant's introduction of materials and testimony contrary to the consent order. Because of the consent order, we ask you not to consider this objection when you make your decision, but we want to include it in the record. Thank you.
Thank you. Is there anyone else from the public who would like to speak?
Very interesting what you have to say today. We're running shy into the time. It's not our fault. Will you be wise to hear from the applicant's attorney? So, you want to go to the standard of care, but we get this done also.
Okay, I'm just going to make a summarization. And I'm not going to ask questions.
Okay, would you raise your right hand, please, swear? Do you solemnly swear the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And please state and spell your full name and provide your address.
Felicia Palm,
Alicia Palmer, 296 6th Street, Jersey City, New Jersey. One point that was mentioned in the testimony of Mr. Bilal, Mr. Donato questioned the validity of his demonstration of that the property was transferred to. She questioned the validity of his determination that the property was not designated as commercial, that it was designated according to the transfer of the property, that they had not checked off commercial, they checked it off as vacant land, I believe, when the property was transferred. It wasn't checked off as commercial or residential. Okay, I'm just making, because I don't need to question them, I needed to verify that information, but I'm not able to question them. Based upon, my whole assertion is, the version of the real estate appraisal book that was used was the fourth edition that was used from 2002? Okay, so I don't have the opportunity to ask you questions, I'm just going to make a statement. The version that was used was the appropriate version. When the transfer was made, the version that was used was the version that the person that made the transfer used to make their designation. So if he's making the transfer of the sale of the property at a particular time, they would use whatever version was available at that time, which would have been the version from 2002, which would have been the fourth version. So essentially, if Mr. Bilal, you're shaking your head. No. Okay. So if Mr. Bilal is stating that he used the version that was available, I think you said he used the third edition or the fourth edition? The third edition. Okay. If Mr. Bilal is using the third edition, I'm having a lot of problems talking. Now it's too loud. Okay. The bottom line is, the transfer was made at a time, and at that time that the transfer was made, they had the opportunity, using the fourth edition, to make a determination that it was commercial. They didn't check off commercial at that time. Therefore, they shouldn't be trying to refer to getting a reasonable return based upon a commercial definition, if at that time the document, the book stated this is the definition for commercial, and they did not select that as a definition in their transfer. So the book says, fourth edition, that's what they would have used because they did the transfer after that book was published. The definition of commercial is stated in that document. Commercial is not listed in the transfer document. So they would have known that that was what the definition was. They didn't choose it, they chose something else. Therefore, they can't now say that it's commercial when before they didn't choose it as commercial. That's the point. So just to look at when the transfer took place and exactly what the language was at that time that the transfer took place, that's the key, in my opinion, to determining whether you should get a reasonable return or a 12% return based upon commercial, residential, or open space. That's it.
Okay.
I would really like to thank you for your time. You've spent an awful lot of time on this. And you've raised every question under the sun that could possibly be thought of. But there remains a bottom line here, and the bottom line is simply this. There is an embankment wall. Some could question its aesthetic and historic value. You do not. But bottom line still remains that a property owner has a right to a reasonable use. And I ask you, in your consideration on this hardship issue, to really think about whether this entire journey into trying to decide whether or not development of two-family as of right homes on 4 of the blocks, the 3-family on the Manila block, is really something that you would seriously want to see on top of the embankment walls. I just find myself in this situation of being rather incredulous. I'd like also to respond to the comments that were made by the last speaker, because she just misunderstands that the 4th and current edition of the dictionary is from 2002. The deeds that you have on file on the transaction are from 2005. So the definition that we are relying upon from the critical real estate appraisal dictionary was in effect at the time of the transfer. You are obviously in a difficult situation because you have a citizen group that refuses to consider that the embankment is private property. We've had speaker after speaker get up here and say, it's a public asset, it's art history, it can't be touched, it's equivalent to the pyramids. They just do not want to understand. They don't want to compromise. They don't, for years we've shown that efforts have been made to come up with proposals that could save all or some of the walls. And the sad part about it is that that refusal has been driving a municipal effort to prevent these property owners from gaining any reasonable return on these properties. And the city's misfortune is that it is a very well-placed property owner who can wait, and he will get his approvals. We will get the approvals that are necessary because the law is on our side. And you can nitpick the numbers, you can find this wrong and that wrong, and you can disbelieve everyone. But we have presented absolutely incredible proofs, and you have nothing on the other side but speculation. People are urging you to violate constitutional rights. And I have been here for many an evening, and I've listened to each of you and the comments that you have. And I ask you not to do that. Not to put yourselves in a position, which many boards do. When the public comes up and doesn't like something, they say, let's let the courts decide it. We'll just say no. Don't do that. And if you're going to, if you really think you want to see a single family option up there, do what your ordinance allows you to do. Comment on it and allow something to be furthered because it will not go beyond what you've seen if you do not comment favorably. And the clients will not do it, and I understand why not. It appears that nothing can satisfy the Embankment Coalition, but you are not the Embankment Coalition. And I ask you to fairly look at the evidence that we have submitted and realize that you have one witness who used an almost 15-year-old dictionary to substantiate his position. We ask you to please consider the facts and fairly rule that we are entitled, both under the commercial and the non-commercial standard, to a hardship exemption. Thank you.
Thank you, Mr. Donato, for your hard work. Appreciate it. Okay. Mr. Chairman, if I may have a moment, I'm going to instruct you as to how you want to proceed in this matter and engage in your deliberation. First of all, it is your job as members of the Historic Commission to make findings of fact with respect to this economic hardship petition. In regard to that, you must consider the ordinance 345-3 and all of the Jersey City land ordinances that are appropriate and pertinent thereto. There have been a number of different references with respect to R1 zoning, limited zoning, with respect to issues as to definitions. You are to soundly, in your own discretion, consider that information. In addition, you must be satisfied. The burden of proof rests with the applicant to satisfy you that, in fact, an economic hardship, in fact, exists. The first issue you must determine is the issue is to what standard should apply. You should never, or should saying that in fact it is not commercial at all. You shall determine that issue, and then with respect to that issue, you shall proceed to see whether or not you are satisfied that you have had the requisite documentation, the requisite burden of proof establishing that in fact a hardship exists. In this case, there is testimony from at least one witness that an alternative proposal is feasible. You may consider that as reasonable testimony, and you may accept that testimony with respect to whether or not an economic hardship exists, which is the fundamental requirement and burden that you now encounter. There have been a number of different scenarios with respect to cost. The issue of cost on one side or the other are not of the moment. The issue of being satisfied, having conviction that you have been persuaded properly that in fact an applicant is entitled to an economic hardship based on the information that you have to use. In order to do that, you alone should assess the candor of the witness. You should assess their appearance, their hesitancy, their lack of hesitancy, their apparent forthrightness, the manner in which they testify, and frankly, their overall candor. That alone is within your purview to do and is required in making your determination. In addition, you have heard information from the co-applicant comment. Without going through the testimony, there was information that was sought. The importance of that information, you alone shall determine whether or not that is a factor for you to consider when making the determination as to whether an economic hardship exists. The totality of applicant, the co-applicant, evidence produced. If you are not satisfied, if you cannot conclude that you have reasonably been satisfied that under all of the scenarios that an economic hardship exists, then in your exercise of your judgment, you should deny the application. If on the other hand, if you determine that in fact there is an economic hardship, that they have ignored their burden of persuasion, then you are to so know and grant economic hardship, allowing the applicant to bring the wall down and continue in his approval process. Finally, I want to comment about something that's been referenced. Ms. Donato has mentioned a number of times that you have been precluded from giving any opinion on the concept plans. These are the concept plans of Mr. Donato. I have never instructed and I will tell you, individual members of the commission are not privy, and that is my direction to them. That being said, however, these concept plans, although having the merit that you shall attach to, are not significantly part of the record because this is a hardship hearing alone. This case is still under the current jurisdiction of Judge Garrett. I would ask you to discuss in open your reasons for your findings, one way or the other, so there's full disclosure to you. If you have any questions, you certainly.
Thank you, Mr. Dean. Motion. Commission.
I make a motion to deny the application for economic hardship based upon the testimony that we've heard.
Currently, we have a motion on the floor by Commissioner Minton. And the motion is seconded by Commissioner Thomas. Is there any discussion on the motion? Why do you think we should do that? Okay, well, this is the time.
I have a couple concerns that I think are probably shared by the board, although they can give their input after I give my comment. First, I think that we haven't been convinced that the property is actually commercial. I think we've gone back and forth on that many times. The second is that I think we haven't been convinced or persuaded that the extraordinary costs are justified, meaning we haven't provided sufficient backup to evaluate the extraordinary costs. And the third reason that I would state is because the Marketo presentation of the castle on the hill, the 5,000 square foot homes, presents an option that would give a reasonable return for a non-commercial property.
I essentially, my feeling is that the burden is upon the applicants to establish to our satisfaction that a hardship exemption is required because a hardship exists. First of all, if we're looking at the ordinance 34530, section 2B3, we really haven't heard anything convincing that this property should be considered anything other than non-commercial. Specifically, Judge Galapoli's ruling was quite clear about the railroad overlay ceasing to exist once the use had ended, and then the underlying zoning there remains. If we look at the ordinance, the non-commercial part of the ordinance is silent on the return that can be expected. So the whole concept of looking for a 12% return is not established anywhere therein. Some questions were also brought to my mind. I only heard it once, or maybe I heard it twice. We've been talking about, I think, 6 parcels, and yet the purchase, there were 8 parcels. That may be an error, but I'm pretty sure I heard that twice. And I haven't heard anything about these other 2 parcels. Although that isn't the basis for my denying the application, it certainly raises questions. Finally, I know I'm on the record at least on 2 occasions, on 2 separate days, where I asked for more clarification, breakdown, and specifics on these exceptional costs. Our first piece of evidence had a footnote that made mention of 3 very vague areas where these costs were attributed to. And then we did have a presentation which showed us a per house breakdown, and I'm fully confident that the cost per square foot, or at least for each of these homes, was fine. However, I didn't see any breakdown at all. Today we received from CMX a breakdown of the costs that were the same for both scenarios. And this is in considerable detail. I do not know why we couldn't have received something similar for the exceptional costs. The exceptional costs, I just took a look at it a couple minutes ago. I don't see anything about piles. I don't see, remember that this structure carried railroad train, vibrating, trundling along. I'm certain there are point loads to be considered, but I guess, with no disrespect to the engineers who work on this, with your only tools and hammer, everything begins to look a nail. I'm sure there's more than one way to skin a cat. I'm certain there has to be another way in which something could have been developed to support these structures. I firmly believe that it would cost as much as they stated to build a steel deck. I am just not convinced that a steel deck is necessary. And then, of course, I find that really all of that is irrelevant because testimony was presented that there, at least to my feeling, there are alternatives that would provide a significant return. Forgetting about the castle on the hill, we saw a concept plan for some single-family homes that looked quite intriguing to me. And although we didn't receive any specific numbers, I can find no basis for a hardship exemption to be offered here.
I'm wondering if you could add a little clarification to the motion. I wanted to add, other than testimony, section 345-32B. In my money, it would be section 4, which reads, in case of the proposed demolition, an estimate of an architect, developer, real estate consultant, appraiser, or other real estate professional experience rehabilitation as to the economic feasibility or rehabilitation or use of the existing structure on the property. Let me add that to the motion. Yeah.
Yes, sure. Second.
I'll second.
For a reason that I'm compelled that by Mr. Blau's testimony, that the property is non-commercial, also based on current zoning, as was ruled by Judge Galopoli, that it is non-commercial. I'm also not convinced that the applicant has demonstrated an economic hardship under the non-commercial criteria. I point to the testimony of the applicant's own architect that one of the development plans would yield a reasonable return. I would point to the applicant's own architect. I would point to the applicant's own architect that one of the development plans would yield a reasonable return without demolition of the existing structure.
Well, after listening to expert testimony for many months,
Can't hear.
after listening to expert testimony from both sides, for many nights, maybe 25 hours of testimony, I have to agree with Mr. Black's testimony, indicating that the property is in fact non-commercial. Also, the substantial testimony by Mr. Marchetta, I was very impressed with his plans, and I do believe that the property could yield a return. No economic hardship will exist from it.
I'm going to reiterate what several other commissioners have talked about, which is the presentation, the PowerPoint presentation that we saw. We were given nothing in advance. All these numbers were on a screen. There were, as they said, there is no backup to any of them, and it would be impossible to even make a reasonable judgment as to the validity without that information. But one of the things I noticed with the difference between the two is that there was never any mention made of the value of, or the premium that you have mentioned in the applicant's appraisal, that there is a premium to having a building on top of the embankment, and that's not included in those numbers. So I was unconvinced by the presentation, but would have appreciated having information and backup so that we could have made a better judgment.
I have to agree with my fellow commissioners. No evidence that presents us that convinces us that this is nothing other than a residential property. It's a non-commercial property. That falls in the economic hardship case. We don't know what Conrail's, what their price is, what the cost is, the return of getting on the billboards. I don't believe we got a full cost breakdown for the construction and extraordinary costs. So I'm inclined to deny the economic hardship.
There's a motion amended on the floor. There is a motion made by Ethan, seconded by
advisory role. I've been on the commission for 5 years, and we have never received an application on this property other than a demolition. And if there was a different type of application, then consider advisory role. But because it's for demolition of the entire property, I would advise to demolish it.
Okay. How do you vote? Commissioner Tomas?
I vote to deny application for economic hardship.
Commissioner Guardiola?
Deny.
Commissioner Minton?
Deny.
Commissioner Sadkow?
I vote aye to deny based on 345-32B4 and testimony.
Commissioner Martin?
I vote to deny.
And Chairman McNeil?
I vote to deny.
In the motion to deny certificate of economic hardship, the Commission votes 6 to deny, none against, with no abstentions. The motion carries. The certificate is denied.
If we look at the ordinance, the non-commercial part of the ordinance is silent on the return that can be expected. So the whole concept of looking for a 12% return is not established anywhere therein. Some questions were also brought to my mind. I only heard it once, or maybe I heard it twice. We've been talking about, I think, 6 parcels, and yet the purchase, there were 8 parcels. That may be an error, but I'm pretty sure I heard that twice. And I haven't heard anything about these other 2 parcels. Although that isn't the basis for my denying the application, it certainly raises questions. Finally, I know I'm on the record at least on 2 occasions, on 2 separate days, where I asked for more clarification, breakdown, and specifics on these exceptional costs. Our first piece of evidence that we given us had a footnote that made mention of 3 very vague areas where these costs were attributed to. And then we did have a presentation which showed us a per house breakdown, and I'm fully confident that the cost per square foot, or at least for each of these homes, was fine. However, I didn't see any breakdown at all. Today we received from CMX a breakdown of the costs that were the same for both scenarios. And this is in considerable detail. I do not know why we couldn't have received something similar for the exceptional costs. The exceptional costs, I just took a look at it a couple minutes ago. I don't see anything about piles. I don't see, remember that this structure carried railroad train, vibrating, trundling along. I'm certain there are point loads to be considered, but I guess, with no disrespect to the engineers who work on this, when your only tool is a hammer, everything begins to look a nail. I'm sure there's more than one way to skin a cat. I'm certain there has to be another way in which something could have been developed to support these structures. I firmly believe that it would cost as much as they stated to build a steel deck. I am just not convinced that a steel deck is necessary. And then, of course, I find that really all of that is irrelevant because testimony was presented that there, at least to my feeling, there are alternatives. that would provide a significant return. Forgetting about the castle on the hill, we saw a concept plan for some single-family homes that looked quite intriguing to me. And although we didn't receive any specific numbers, I can find no basis for hardship exemption to be offered here.
I'm wondering if you could add a little clarification to the motion. I wanted to add, other than testimony, section 345-32B. For my money, it would be section 4, which reads, in case of the proposed demolition, an estimate of an architect, developer, real estate consultant, appraiser, or other real estate professional experience in rehabilitation as to the economic feasibility or rehabilitation or use of the existing structure of the property. We can add that to the motion. Yeah.
Yes, sure.
I'll second.
For a reason that I'm compelled that by Mr. Blau's testimony, that the property is non-commercial, also based on current zoning, as was ruled by Judge Galopoli, that it is non-commercial. I'm also not convinced that the applicant has demonstrated an economic hardship under the non-commercial criteria. I point to the testimony of the applicant's own architect that one of the development plans would yield a reasonable return. I would point to the applicant's own architect.
Just speak louder.
I would point to the applicant's own architect that one of the development plans would yield a reasonable return without demolition of the existing structure.
Well, after listening to expert testimony for many nights,
Can't hear.
after listening to expert testimony from both sides for many nights, maybe 25 hours of testimony, I have to agree with Mr. Black's testimony, indicating that the property is in fact non-commercial. Also, the substantial testimony by Mr. Marchetta, I was very impressed with his plans, and I do believe that the property could yield a return. No economic hardship ever exists from it.
I'm going to reiterate what several other commissioners have talked about, which is the presentation, the PowerPoint presentation that we saw. We were given nothing in advance. All these numbers were on a screen. There were, as they said, there is no backup to any of them, and it would be impossible to even make a reasonable judgment as to the validity without that information. But one of the things I noticed with the difference between the two is that there was never any mention made of the value of, or the premium that you have mentioned in the applicant's appraisal, that there is a premium to having a building on top of the embankment, and that's not included in those numbers. So I was unconvinced by the presentation, but would have appreciated having information and backup so that we could have made a better judgment.
I have to agree with my fellow commissioners. No evidence that presented us that convinces us that this is nothing other than a residential property. It's a non-commercial property. That falls in the economic hardship case, and we don't know what Conrail's, what their price or the cost of their return to getting on the billboards. I don't believe we got a full cost breakdown for the construction, extraordinary cost. So I'm inclined to deny the economic hardship.
There is a motion made by Pittman, seconded by
advisory role. I've been on the commission for 5 years, and we have never received an application on this property other than a demolition. And if there was a different type of application, we would then consider an advisory role. But because it's for demolition of the entire property, we would advise to demolish it.
Okay. How do you vote? Commissioner Tomas?
I vote to deny the application for economic hardship.
It's been voted.
We vote to deny the economic hardship.
Commissioner Guadiana?
Deny.
Commissioner Mendon?
Deny.
Commissioner Sackett?
I vote aye to deny based on 345-32B4 and testimony.
Commissioner Martin?
I vote to deny.
And Chairman McNeil?
I vote to deny.
In the motion to deny a certificate of economic hardship, the Commission votes 6 to deny, none against, with no abstentions.